If you don't have an estate plan, what's going to happen to your stuff? Just to kind of find out where everybody's at, first I wanted to ask, is anybody got their estate planning all finished? Kind of. Has anybody had estate planning done many years ago and you're not confident that it's what you want? Okay. Has anybody not done any estate planning at all? How many people are here looking to get some advice or just a little bit of learning, but you're not ready to start estate planning today? Okay. Let's see if this is working. All right. Also, is anybody here a military veteran? We do, our office, thank you for your service. Our office gives discounts to military veterans. I'm a military veteran myself. I founded this firm, Krause Estate Planning and Elder Law Center, in 2000. I've been doing estate planning for 25 years. I guess that's easy to do that math. But when I first started, I was also doing criminal defense, divorces. I did some bankruptcies, essentially getting to know the court system, getting to know what I liked and didn't like. I didn't start out in law school thinking, I want to be an estate planner. But as soon as I finished law school, my grandparents approached me and they said, now you're an attorney, you can help us. We want to make sure that we don't lose the homestead, which is 5 acres of sandy ground in Wisconsin Rapids, worth about 40 grand, actually, in the end. They didn't want to lose that in case they ended up in a nursing home. So after law school, having not studied that at all, I studied the philosophy of law. I was a big thinker. I wanted to be with the eggheads and talk about, is this proper or is that proper? But what I ended up really loving is helping people to make sure that their affairs are in order. So over the years, for the first 2 or 3 years, like I said, I did whatever came in the door. And then I started lopping off parts of my practice. And by 2004, I was estate planning and probate. I didn't start elder law until about 2010. Elder law, from my point of view, is helping people to not lose everything to nursing care. Nursing care, assisted living care, end-of-life care. Does anybody have a problem hearing me? Okay, good. So, this is just a picture, a selfie I took before I retired in 2016 with my BCGs on. Does anybody know what BCGs are? Military guy, being in the Army. BCGs are these glasses that they give you. Everything's free in the Army, but they're not really what you'd want to wear out on a date. And that's why we call them BCGs, because they're called birth control glasses. Nobody's going to go on a date with you if you have these things on. So yes, I concentrate my practice on estate planning, elder law. I've been doing it for a lot of years. I'm actually licensed in Wisconsin, Minnesota, and Illinois, although I just practice in Wisconsin. That's the laws I know, and if I'm asked to do something in Illinois or Minnesota, sometimes I'll take it on if it has a Wisconsin component to it, but I don't try to do business in those states. And one out of, there are 7 estate planning law specialists, board certified specialists in Wisconsin. I'm proud to be one of those specialists. I wrote a book. You've seen a copy of the book. My firm and I are members of a lot of organizations that focus on estate planning. We also have many kudos and A+ on the Better Business Bureau, lots of stars on Google. Just a little bit of bragging right there. So let's jump into what is estate planning. Estate planning is essentially making a plan, usually a written plan, for what's going to happen if you become incapacitated or when you die. That's it. Now, estate plans have the purpose of making things easier, making sure that your wishes become reality if your wishes are different than the government's default. Because if you haven't engaged in estate planning, you still have an estate plan. Believe it or not, the government's written one for you. Everybody has an estate plan. It's a choice not to do one yourself because maybe people are happy with what the government wants to have happen. And we can talk what the specifics are. If you don't have an estate plan, what's going to happen to your stuff? If you don't have an estate plan and you become incapacitated, what's going to happen to you? Who's going to be in charge? Who's going to do everything? Who's going to make decisions? So we want to minimize taxes, maximize privacy, maximize control within your family, not control within the court system, not control of the judges, your family members, and give them control over what's going to happen. The minimum requirement for anybody that should have, over the age of 18, any estate planning, you need to have a will, a financial power of attorney, and healthcare power of attorney. I would consider that a comprehensive estate plan. Now, just so that you know, the estate plans that I do for my clients typically involve, if it's a single client, what we call a fairly simple plan, still involves a dozen documents that they're signing. But these are included, always. All right, so reason number 1, 4 reasons that you should do estate planning today. Because something could happen tomorrow. What could happen? You could lose capacity. How could you lose capacity? Well, there's strokes, there's car accidents, there's sudden illness. You might not be able to make decisions tomorrow. And I hope that doesn't happen to any of you. Hope it doesn't happen to me either. But it could happen. So, what if you don't plan? Well, here comes the first time of the theme. The government has a plan for you. State law controls what's going to happen if you don't have an estate plan. So, guardianship is the solution. The state has the solution of guardianship, and so what they do is if you've lost capacity, you need to sign something, you need to move, you need to be able to pay your bills. Somebody needs to be appointed as your guardian. If you haven't done powers of attorney, your guardian has to make these decisions for you, and a guardianship is a pain. Guardianship goes through court. You have to have at least 2 attorneys involved, one to bring the guardianship and the other one to represent the best interest of the potential ward. The best interest is represented by an attorney called a GAL. If you've ever heard of that, it just means guardian ad litem, and in Latin, it just means the attorney that looks out for the person who can't look out for themselves. The court then supervises your life. Now, the judge or the judge's secretary isn't going to call you up and say, "How you doing? We want to make sure that everything's fine and that you got enough food and stuff." They make the guardian report every year. And they're mostly concerned about your finances because that's the thing that's easiest to look at on paper. They don't come to visit you. They may send a guardian ad litem out to visit you to see whether you're being cared for, whether you have enough to eat, etc. But who is the guardian? The guardian may be somebody that you don't know. It could be a person that you know, but you would never choose them to be a guardian for you. These are all possible things. It's all up in the air when you go for a guardianship. If you have lost capacity and you haven't done a proper power of attorney, now when I say proper, it has to have specific language in it, then you're looking at spending down all your assets if you need long-term care. The same thing goes for a guardian. If you have a guardian, they're not allowed to try to save your assets for your family. They're not allowed to do that. They have to conserve your assets and use them to pay for your care and pay for their own salary that they earn by doing that for you. Those are the things that they can pay for. Anything else they have to ask the court about. And if they ask the court, hey, we want to engage in some of these planning that Dan has been talking about. Dan told us that we could save the house. And the court will say, no, you can't do that because you're a guardian and you have to spend all the money on the care. You can't try to get it to the kids. So that's guardianship. So while you are alive and not competent, you need to have power of attorney for finances, the power of attorney for health care. If you have both of those things, you got most of your bases covered. Now, the power of attorney for health care is a fairly standard document. It doesn't vary from one person to the next. Now, I've seen some from other states. They're still valid in Wisconsin, but the clinics and the doctors have never seen those before, so it makes them wonder whether it's really valid, and it causes confusion. But they're pretty much all the same. Now, powers of attorney for finance are not all the same, and there's some big differences. And I want you to know that the one that you download from the state, it's great that you can download these for free. You can get them off the Department of Health Services website. The problem with these powers of attorney is you think that you're allowing your agent, the person that you name, you think that you're allowing them to do everything that they might need to do, including saving your assets from spending on nursing home. But if you take the form and you initial in every spot they give you to initial, and then you sign it at the end in front of a notary public, it's a perfectly valid power of attorney, but it does not allow anybody to try to do some of the things to save your assets, to save your home, to save your savings from nursing home costs. It does not allow that. You have to put in special language. Special language needs to be inserted about gifting to allow your agent to gift your assets. You have to say the gifting is not limited. You have to say that the gifting can include gifts to the agent if your child is your agent, so they can give themselves assets to try to save them. It needs also to say that your agent can create a trust for you, an irrevocable trust. This is how we save assets. If they don't have that language in there, the law says you can't do it. So the form that the government gives you to do this does not have any of that language. Warning. Now, if you are a do-it-yourselfer and you want to do it yourself, I have created a YouTube video that you can just search for my name, Dan Krause, free power of attorney language. And you can download, and if you look on YouTube, you got to go underneath the video, and then there's some text. And there's a link where you can download the form from the state, and then there's some text that you can cut and paste in this box that's on that state form. So if you're a do-it-yourselfer, that is a way to make your documents much, much better than they would otherwise be. One good hint. Also, another thing that you can do to protect yourself and your wishes is do a living will. Now, Wisconsin Living Will allows you to say, essentially, pull the plug if I'm in a persistent vegetative state, a vegetable. Or it allows you to do pull the plug if you have a, what do they call it? A terminal condition. A terminal condition is where you're beyond the point of communication and your death is expected to be imminent. So it's within the next day, hours, or days maybe. So even though your neighbor might say, I have a terminal condition, you see him out mowing the lawn. That's not this, okay? You can, if you have a terminal condition under the law, you're flat out in the bed, you're non-communicado, and the doctors believe you're going to be gone within a couple of days, okay? In these cases, Wisconsin allows you to say, stop all treatment. It allows you to say, no feeding tubes. But you have to fill out the document. Otherwise, they will keep you alive according to their procedures, okay? So, does anybody remember the Terry Schiavo case? Does anybody feel that name is familiar anyway? I'm going to tell you the story. Terry Schiavo, and I can't tell you exactly the year, but I think it was 1993. was 28 years old, I believe, and had a heart attack. Now, I don't know what caused the heart attack, but her heart stopped long enough for her brain to run out of oxygen and become irreparably damaged. And then she was revived. Her heart started beating again. The rest of her organs recovered. They were fine. Fast forward 15 years and she's still alive. Has not gotten out of bed since the heart attack. Has not said a word. Some people are saying, oh, I've talked to her and she moved her fingers, she fluttered her eyes. Yes, it's true, people have these autonomic responses, but there was this big outcry. We've got to save her. She's in there. We can't allow her to die. Congress weighed in. The president came back early from vacation. George W. Bush, he wanted to say what he was going to say. The Supreme Court got the case, and they threw it back down to Florida. It wasn't until 6 years after she had that heart attack that her husband asked the court, can we please pull the plug? The parents, unfortunately, disagreed. Fortunately or unfortunately, however you feel about it. But there was a fight. The husband, after 6 years of her being in a coma, wanted to say goodbye. The parents said, no, she's going to come back. We just know it. You can imagine the heartbreak. Parents never want to let go. So they fought over it in the courts. Money, money, money for treatment. Money, money, money for court bills. They're a wealthy family. So that's why we've heard about this case. 15 years on life support until finally the Florida court said, okay, we can pull the plug. And then she passed away within a week or so. So that's the Terri Schiavo case. If you haven't put your wishes down, it's possible that that can happen to you. God forbid. But that's why we have this planning. The government's plan, keep you on life support. The hospital's plan might even be to keep you on life support. They make money that way. Trusts are another way that you can control your assets during your lifetime. If you create a revocable trust, your trustee, if you become incapacitated, can take over, manage your assets, invest, pay the bills, have access to your bank accounts. As long as everything is in the trust, they can wind all that up. All right. So that's reason number one, you could become incapacitated. Reason number two, you may die. We've heard it 1,000 times. You never know if tomorrow is going to be here. And that's very true. Planning is too late after you die. A lot of people come to me and they say, well, my mom always wanted me to have this thing. And now she's dead. And I say, well, where's her will? You can't have that thing if she doesn't write it down. She might have told you. She might have told the whole world. It could be, on YouTube or Facebook. She might have written it down and said, here's a picture of my beautiful thing that I want my daughter to have. It doesn't matter unless it's written down in a will. If you don't plan, guess what? Government's got a plan for you. The government's plan is the state law. And in general, the closest relatives get the stuff. So let me just go over how Wisconsin intestate succession works. Intestate succession just means if you die without a will, in no testate testament. No testament. If you have no testament, you don't have a will, you don't have a plan. Wisconsin law says if you're single, no kids, your parents get everything. If you have no living parents, then it goes to the descendants of your parents. So your siblings would be next in line. If any of them had died, their kids would get what they would have gotten. And it goes down the line like that. If you have no people in that line, no nieces, nephews, grandnieces, grandnephews, no parents, then you go up one more time to the grandparents, both sets of grandparents. If they're alive, they can get it. And then it goes down the line from there. So that's aunts and uncles, first cousins once removed, twice removed, 3 times removed. If you have to go up one more time, too bad. Wisconsin does not count that as an inheritance heir. The state gets it. So a lot of people think if you don't have a plan, the state gets it. Very rarely the state does get it, but Wisconsin law says your closest relatives are going to get it after going through the probate process and showing up and asking if anybody has any objections and paying all the claims and everything else through the probate court.
Is there a reason you didn't mention adult children in that list?
Yeah, children. Well, because I started with if you're not married and have no children. That's the situation.
Okay.
So now we go to married and no children. If you're married with no children and you die, everything goes to your spouse. If you're married and you have children and all of your children belong to both of you, it's still everything goes to the spouse.
If you're divorced, single.
If you're married.
But if you have children and you're divorced,
Mm-hmm.
you're not married.
Right. So if you have children and you're not married, everything goes to the children. Or it goes per stirpes. So let's say you had 3 children and one of them, God forbid, passed away. But they had kids. Now things get divided. 1/3 to one kid, 1/3 to the next kid, 1/3 to the grandkids on from this one. So that's per stirpes or by representation descent. So you're married and you've got kids, but not at least one of your kids doesn't belong to your spouse. This is where it gets weird. And we have a lot of second and third marriages, mixed families. If you don't have a plan and you're married and your kids are not your spouse's kids, or you have at least one child that's not your spouse's kids, what happens is everything gets divided in 2 when you die. Your spouse gets half and your kids get the other half, with exceptions. Now, anything that you and your spouse own as joint marital property with rights of survivorship, like if you both got your names on the home, and you got the home when you were married, and it's your residence, that automatically goes to your spouse. The kids don't get any of that. But for bank accounts and for personal property, for other stuff, it gets divided between the kids and the spouse. And people that don't have plans, I see kids don't like step-parents very much in general, usually. And it gets worse after their parent dies. And we hear the stories so often. Dad just died. Mom died 10 years ago and Dad got everything, and then he married this person. Then he died. Now she gets everything. He did a will and given it all to her. And now she just died and her kids are inheriting all the money that should go to us. There's nothing you can do at that point. So it's important to have a plan. All right, probate proceedings. Anytime you don't have a plan, you're going to get probate unless your assets are below $50,000. $50,000 is the magic number in Wisconsin. When I started practice, it was $10,000. You also have problems if you don't have a plan with, as soon as somebody gets 18, they're an adult, they can inherit. So if you have young kids and you don't want them to have the opportunity to be super foolish and just blow everything, then you need to have a plan so that that plan can say, hold my kids' stuff until they're 25 or 30, or a little bit on these particular, give them some when they graduate college if they do, then whatever. You can make rules. But the state's rule says when they're 18, they're an adult. They can do what they want with their inheritance. All right, so we talked about the second marriage situation, and the kids or the spouse or both of them just being really, really unhappy with how things go. There's also problems we've seen with long-term family or familial type relationships, but people are never married. They might even have kids together, but they're never truly married. And so there are problems when one of them dies and doesn't have a plan. They may be together for 20, 30 years, but they're not considered to be, in Wisconsin, related. In 1984, Wisconsin abolished what they call common law marriage. Used to be in the common law and in Wisconsin before 1984, if you were with somebody for long enough and you held yourself out as a family unit, husband and wife, and you kept house together and you had kids together, you were married whether or not you went through the ceremony. That is no longer the case in Wisconsin. All right, so intestacy. This is just a little story that people may be familiar with, may not be. Who knows who this is? Who is it? James Dean. All right, one of the coolest characters in the modern era, right? He was Mr. Cool. He died when he was 24 years old. And 24, it's not surprising he didn't have a will, but in his case, it really caused some heartache and maybe some things that he really, really would not have wanted. So he died at 24 without a will. His entire estate went to his father. His mom had passed away when he was young, 7, 8, 9 years old. The sad part is his dad said, I don't want to raise a kid. Now I don't have a spouse. You go live with your aunt, your mom's sister. So his aunt raised him after the age of 7 or 8. And he was estranged from his father. They did not get along at all. And so until his father died in 1995, he was getting $1 million or more every year from the estate of James Dean because he was the sole intestate heir. This is what can happen if you haven't made a plan. Just a little closer to home, I had a client come in his 90s, perfectly competent, but he was sick. He came in there with his daughter and his current girlfriend, or, they were living together. And he said, this is what I want. And so when I go through here, and then it came out that there was another child that he had like 50 years ago and hadn't heard from him. And the daughter didn't know that she had a brother. It was a little weird. And he didn't want that child to get anything because they hadn't had any communication. It was bad divorce and estrangement and all that stuff. But he died before he could sign his documents. He was dead within a week of our meeting. So now they had to go and look up that brother and give that brother the brother's share of the estate. So it wasn't what he would have wanted, the client, but it's what happened because we didn't get around to signing everything. We didn't think he was that sick. He didn't say he was. All right, so you can have a will. If you have a will, that gets you out of the government's plan, partially. Part of the government's plan, though, is you're going to go through a probate process. And the will does not get you out of that process. There's always court involvement with the will unless, like I say, you have under $50,000. A will does not work without the court. You can have a perfectly valid will. A person dies and you've got their death certificate in your will, and you go into the bank and you say, give me all their money. It says I get it right here. They will send you away. The will doesn't mean anything until you get the court's approval, and the court gives you the documents proving that you have the authority. They appoint you the personal representative. And at that point, the bank will give you the money. Then you can sell the house. Then you can take possession of all the stuff. So probates are average over a year in Wisconsin. They have certain timelines and certain requirements that you have to notify certain people. You have to find them, and sometimes we have to pay private investigators to find people and say, hey, we heard that this person was married before and they may have another child or something like that, and sometimes we find them in Europe or we lose the trail, and then we have to report that to the court, and then we have to set aside a portion of the estate for that person and then deposit into the missing persons or there's a place where you can look up your name to see whether somebody's holding money for you. Has anybody gone to that website? I have. I got $100 from an insurance company or something. They just turned it in for lost money, unclaimed funds. And so that's what you got to do if you can't find the person. But With Facebook, private investigators, credit cards, you can always find somebody. But if you plan without a will, if you plan with a trust, you don't have to go through all of that rigmarole and finding people that you don't really care to be involved. The biggest problem that I see really as probate, and this has gotten bigger over the years. Currently, in our environment, we have got more and more invasion of our privacy. Everything is on the internet. And at the same time, we've got more and more sophisticated scams. And we've got AI looking for money out there, trying to find money in the banks, in people's pockets, and they're specifically targeting a lot of elder folks in this country, because they know that elder folks sometimes don't remember things very well. Has anybody gotten a phone call saying, "Grandma, Grandpa, send me some money"? That's a very common one. People get scammed out of their entire retirement account. They might be in the beginning of Alzheimer's or whatever because somebody found out they had money. Who knows about CCAP, the Circuit Court Access Program that you can get on the internet? So you can get on there and you can find out if your neighbor has any drunk drivings. You can also see information about their divorce. You can find out if the bank is suing them for not paying their debts. You know, it's a lot of fun information, but you can also see if there's a probates going on. So if you've got access to the internet, which, you know, you don't even have to be in this country to get on CCAP, crawl through the database and find out where all the probates are. And then you could crawl through those databases and find the biggest probates. Then you can download the names and addresses of all the interested parties, and you can target them for scams. You can say, oh, there's $1 million probate going on in Walworth County. And here's the names of all the interested people. Let's send them an email, because you can easily find people's email these days. Let's send them an email saying it's from the court, and we need your social security number and your bank information so that you can inherit. Great, let's do that. All right, now comes down, you would get your inheritance, it hits your bank and then disappears. This is a lack of privacy, because if you let your stuff go through the probate court, it's going to be on there. Your family's wealth transfer is going to be public information. And that invites predators. More and more and more. AI doesn't sleep. And it gets better and faster every day, and it's looking for money. What does everything in this world do? Looks for money. It's a business, and it doesn't always look for the legitimate money. It's looking for anywhere that it's easy to bring in money. And if you're out overseas in Afghanistan or wherever you got internet, you can target people in the United States, and they do. All right, so the next reason your heirs could end up in court. And we've been talking about this, but what's the solution? For a lot of people, it's revocable trust. Revocable trust has gained a lot of traction since the 1970s, 1980s, and it's been rolling along. And now, at least in my practice, most of the people that do estate planning have a trust as the basis of their distributions after death, because of the privacy, because they want to make things as easy as possible for their kids, and because they don't want their kids to have to go to court. The kids can manage it at the kitchen table. Nothing gets filed publicly. Nothing is on the internet. Nothing has to be filed in court where somebody can ask to see the files. Nothing like that. So revocable trust is a will substitute. It helps you avoid probate. You have to do it right. Preserves privacy, and you can change it. It's not like your life changes when you have a revocable trust. Once you get it set up, your life goes on. Your taxes don't change. The way that you write checks doesn't change. Nothing really changes, except if you die, kids don't have to go to probate. Many people use irrevocable trust. The most common irrevocable trust that we use is the MAPT, Medicaid Asset Protection Trust, where people, once they paid off their house, they shift it over into a trust and they give the kids the trusteeship so that the kids can now claim that it's not an asset of the parents, or the parents can claim it's not their asset anymore. It can't be taken in order to repay the government for nursing care. You can also put stocks and bonds and cash into these MAPTs. As long as it's in there for 5 years, you can apply for Medicaid to pay for your long-term care, and they can't make you spend that. They can't make you get at that, and they can't penalize you for doing it. So we do MAPTs. Another type of irrevocable trust is just a simple trust for a beneficiary. Let's say you've got a grandchild and you want them to get a certain amount of money, but if you die before they're, let's say, 25, you don't want them just to get it. You want the parent to hold it for them. Invest it, give them money for college, but don't just give them a big lump sum. That's an irrevocable trust. It's called a structured trust for a young person. And then the trustee holds it. And then they come to the trustee and say, I need money for another semester of college. And the trustee says, you haven't gone to a single class in the last 2 semesters. So the answer is no. You cannot have more money for college. You need to get a job and wait till you're 25, and then I have to give you the money. Or you could choose an age. I mean, if you're setting up this trust, you could say 30, 35. I had clients say, I want my kids to have this for their retirement because they are not savers. So we're going to have the bank trust company hold it for them and invest it, and then when they're 60, they can have it. Most people, 25 is the number, but some people say, well, give them a little bit at 25 and let them make some mistakes. Give them some more at 30, and then 35, they can have the rest. But you get to choose when you set these kind of things up. But the trust that is made for those kids is an irrevocable trust. Sometimes we use irrevocable trust for tax purposes, special needs purposes, etc. There's a lot of things that you can do with irrevocable trust. But one thing about irrevocable trust is hard to do is to change them once you set them up. It's not impossible. We try to put as many backdoor loops in there as we can without getting in trouble so that it makes it somewhat flexible, but it's not changeable like a revocable one. If you put money into a charitable trust, which many people do if they have too much income. Is anybody in that situation? If they have too much income, they can put assets in this irrevocable trust during their lifetime. They get a tax deduction this year. But the income from that trust comes back to them for their lifetime. But they can't get at the principal anymore. They can no longer pull that principal out. And when they die, the principal goes to the charity. So they get tax deduction this year, they get income for the rest of their lives, and then in the end it goes to charity. That's an irrevocable trust. But once you put the assets in there, you cannot get them out. Only the interest and income. All right, the fourth reason, you could owe death taxes. Now, the people that are going to owe death taxes if they don't change the laws are something like 0.2% of the population. We've got right now from the bill that passed, a big beautiful thing that passed Congress and the president, now there's a $15 million exemption for every person not to pay any death taxes. So if you're a couple and you plan it smart, you can get $30 million to your kids with no death taxes. It's only the people that have more than that that have to worry about the 38% death tax on what's above that. We've never had such a high exemption before. When I started practicing, it was $675,000, where people with farms were really concerned about having to pay these death taxes. And the death tax rate was 55%. So the people with more than $15 million have been very successful in the last 25 years in getting the laws changed so that they can get more and more money to their kids. So 15 million is the magic number. This year it's 13.99, but then it goes to 15, and then it gets indexed for inflation, so it'll just go up from there unless Congress changes it. So who knows? I mean, Congress it's back and forth, right? If Bernie becomes president, then it'll go down to $1 million exemption, or who knows? So very few people have to deal with that, but if you're one of the people that has more than what can get through the exemption, then you need to do some planning, because there are things that you can do that can save your kids millions of dollars. If you have several $1 million, it's easier to save $1 million. So there are things. Now, the bonus reason, I said 4 reasons. This is the 5th one, long-term care. The boogeyman used to be death taxes. And you sometimes still hear it, death taxes. They're going to come after your stuff when you're dead. They don't, unless you have $15 million. What they do is they make you pay for your long-term care at the end of life. And that's what makes most people run out of money. That's what makes it so most people that have this situation can't give their kids much, if anything. Long-term care, nursing care, assisted living, home care, all of these are very expensive. Cancer care is also very expensive, but we're not going to talk about that because that's paid for through Medicare. You can be a billionaire and have Medicare pay for your cancer treatment, but you can't have somebody pay for your long-term care without spending all of your own money first, unless you've done some planning. If you don't plan, the government's got a plan for you. The state law controls. Now, it's a combination of federal and state law, federal Medicaid law administered by the state. The state makes some of the rules. And so the first part of the government's plan, if you need long-term care, is you spend all your money on it. Now, there are certain things that you can keep. One of them is $2,000. Now, that includes any stocks and bonds that you own. It includes the face value or the cash value of any life insurance policies. It includes all your savings, CDs, bank accounts. $2,000 limit if you're a single person. You also, though, get to keep your home. So you can go on Medicaid if you have $2,000, your home. You can also have a prepaid funeral that you've gone to the funeral parlor and you paid for that. They won't make you try to cash that in. You can also keep your knickknacks, so they don't look at your pots and pans and your china and your jewelry and silverware. Okay? You can keep all that. And then you can be on Medicaid. So a lot of people say, oh, I can keep my home. That's really what I want to give to the kids. Step 2 of the state's plan is to wait till you die, and then they take your home to repay Medicaid. Anytime somebody's on Medicaid over the age of 54, so 55 and above, they keep a tab. I don't know whether they keep it accurately because they never give you the full tab. They just tell you the number in the end. And they say, sorry your family died, you owe us $197,000. So there's a lien on the house, and if you don't sell it pretty soon, we're going to foreclose. This is the state recovery program. Wisconsin's state recovery program has gotten to be fairly efficient in finding assets of people who have died if they've been on Medicaid. And I've had several families of my clients be bothered and pestered by them. Even though we've done the right things and protected the assets, we have to prove it, and then the state backs off. But most of the time, for regular everyday people, they get what they want. They get the house. They get whatever it is. So this is the state's plan. Essentially, you pay for all your care until everything's gone. So that's the state's plan. What's your plan? What should your plan be? Your plan should be to keep your house, your farm, the family vacation property up north, whatever you got for the kids. Keep most of the money set aside for your security. If you do need nursing care and you're on Medicaid, they don't always pay for everything. So you want to have something stashed away that your kids can grab at and give you the extra things. Get you some extra physical therapy, get you somebody that's going to come in and give you massages, maybe take you to Disneyland, whatever it is. If you put your money aside 5 years before you ever apply for Medicaid, you can put unlimited amounts aside. Now, it's rare that somebody's going to put $3 or $4 million aside, because a person with that kind of money can typically fund their own care, right? They can get into the facilities that won't take Medicaid, the top of the line facilities with the huge windows and the butler and whatever. I don't even know what they have in there. It's a great way to go, but very few people can afford that.
Dan?
Yes.
Is it just Medicaid, or are you including Medicare?
Medicare is not a concern because you don't have to go broke for that.
Okay,
But Medicare does not pay for nursing care.
okay,
Medicare will pay if you need to go from the nursing home into the hospital because you fell, or you have a cancer, or you have lung problems, then Medicare pays that bill. It can pay that bill. Many people just have Medicaid pay everything.
don't most people that are on Medicaid have no funds?
Well, yes, exactly. Most people that are on Medicaid have no funds because they haven't done any planning, so their family doesn't have any funds they're holding for them either.
But they'll come after the family to get that money?
No, I want to make it clear. They just come after the house if you have the house,
Oh, okay,
or if you have any kind of life insurance. They take the life insurance proceeds. Usually you can't have life insurance if you're on Medicaid because they don't give you enough to pay the premiums. You have to use all your income to pay for your care, and then Medicaid makes up the difference. They let you keep $45 a month. Now your kids might still be paying that premiums for life insurance policy, but that might backfire on them because the state law says that the recovery program gets the benefits of that life insurance policy. Yes, ma'am.
So if there's no way to protect your long-term care expense with Medicare and only with Medicaid, but you have to spend down to get, so either way you're in trouble.
Well, that's where planning comes in. You can do a plan where you can keep everything, but you have to plan early, and you have to trust your kids. That's a really important thing. Now, it's possible that you could turn over all of your assets to somebody besides your kids, but it's rare that somebody will do that. But for people who are ready to say, think about these things, it's now starting to transition to the next generation, and say, hey kids, we're going to put the house in this trust. If we need to sell it, you're the only ones that can do that. But we understand that you're going to do what we say, even though the trust says we have no control. It's a kind of a moral control. Everybody knows it happens, but there can't be a legal control, because if your kid says no, that's the end of it. You can't sue them to make them sell your house or give you any money that's in that trust. You just have to trust them to do it.
But there is a 5-year window then for that?
So when you start planning, yeah, if you put the house in there, you shouldn't be applying for Medicaid for 5 years. So it's better to plan when you're relatively healthy and younger.
Yeah.
There's also long-term care insurance. First you, and then I'll get to you. If you're young enough and healthy enough, you should look into long-term care insurance. And even if you're not young and healthy, look into it. It might be a good option for you. There's a lot of different types of long-term care insurance. It's a special insurance. It doesn't come just as part of your health insurance. You have to buy the long-term care policy, and then they'll have limits. They'll have daily, monthly limits, and then they'll have a cap as to how much you can have a lifetime. They're sometimes worthwhile. If you've got one that's 20 years old, you've got a doozy of a policy. Don't let it lapse. because they don't come like they did before. Yes, ma'am.
If there's a married couple and there's a need for Medicaid for long-term care, the person who has that need goes into long-term care. They do not own property, they're in a rental space. And the person who goes into Medicaid was the primary breadwinner, and they're the one that has the pension. What happens to the person that does not need primary care? Do they have access to the pension or Social Security of the person who has to go into the long-term care?
So they're married, right?
They're married.
Yeah, so if you're married to somebody that needs care, they allow the person that doesn't need care to keep, and they change the number every year, but it's about $3,300 a month of the joint income. So the person that doesn't need care can keep all of their income. And if it's under $3,300 a month, they can keep part of the other person's or all of the other person's as well. That's how that works. Yes, ma'am.
Can't you just put the house in a TOD?
Can you put the house in a TOD? You can, but it's not going to protect anything. They will take the house and pay for your care. Yeah, a TOD is a way to get your house to the kids
Right.
or whoever after your death.
Okay, right.
It's a substitute for a will. It can be a substitute for a trust. But it doesn't matter if you're on Medicaid. The TOD doesn't work.
Okay. But if you don't need...
A revocable
Medicaid-
trust doesn't work either.
Right, okay.
Right. So if you don't need Medicaid, so to let everybody know, TOD is transfer on death. Let's see. All right, so there's different ways to transfer stuff on death. This is a chart that I made. POD and TOD can accomplish some things, but they fail in a lot of different situations. So it may work to transfer your assets without a probate. It will not protect it, and sometimes it fails. So this is a do-it-yourself type of a way, and if you're looking at doing it yourself, you might want to look into POD, TOD. I don't recommend it for clients of mine. I don't help them do that because if one of the many things that can go wrong with the POD, TOD happens, then their family sues me because I could have used a trust and avoided all that. So one of the things that could happen is your beneficiary, let's say, is a disabled person, and now they're knocked off of their benefits because they're inheriting. And there's nothing that you can put in the TOD that says, but if they're disabled, then it needs to go into a special needs trust for them. It's just the name of the person. Another thing that could happen is you and that person that you wanted to get it are in the same car that goes over the cliff and you both die. Now you have to have a probate anyway. Whereas with the trust, you could say if this person dies, then it goes to this person and then that person and the other person. And you can make a list of things going that way. So yes, a TOD can avoid probate on real estate if you do a TOD deed. It's riskier than I like to be, though.
Okay.
All right, let's see. All right, keep most of the money for your security. A lot of this involves setting up irrevocable trust and trusting your kids. All right, so the bottom line is don't wait. I mean, we can't help anybody here do an entire estate plan by tomorrow. So, you could die tomorrow. We can't help you there. But if you wait for a couple months to die, we can have you covered by that spot. So also, just please, if you know somebody who's losing capacity, but they're not there yet, I mean, they're forgetful, but they know their family, they know what they own, they're still cogent, have them do a plan. Because when they lose capacity, it's too late. They can't do the powers of attorney anymore. They can't sign those things. You can't help them. The only thing they can do after they lose capacity is go for the guardianship, and that is just a nightmare. I don't wish it on anybody. So please, if you're thinking about it, keep in mind that doing nothing is making a decision to go with the government's plan. And if that's okay with you, then that's okay with you. I would love it if all of you would hire me to help you with their estate planning. But if you don't want to hire me, do it with somebody else. Get some more education on it. Get comfortable with something, but please, just do something. I love estate planning. I love to talk about estate planning. I could talk about it for another hour, but we're at the end of our time. Is there any further questions? Yes, ma'am.
The power of attorney for finances, I thought that had to be signed by 2 doctors stating that the person is not within the ability to make decisions.
Okay. So the question is, do 2 doctors have to sign the power of attorney for finances? The answer is maybe. The health care powers have to be activated by 2 doctors or a doctor and an advanced clinical practitioner. Okay? 2 of them have to sign saying that you can't make medical decisions for you. Powers of attorney for finance, the one that you download from the state, is active immediately when you sign it. No doctors have to be involved. You can be perfectly healthy and walking around, and if somebody has your power of attorney, they can also sign things for you.
Oh,
I like these immediate powers of attorney for some people, but many of my clients say I only want it active if I'm incapacitated, so we write that in there. So some powers of attorney are activated by doctors or some other way, and other powers of attorney are immediately active.
oh, and I worked in the healthcare field, so
So you're
my
used
patients
to,
were dying. And
so the
that's
doctors would
what I heard.
activate the
Yeah,
healthcare
yeah.
powers of attorney. Yes, ma'am.
For any of these documents, when we do them on our own, do you suggest that we have them reviewed by an attorney?
So it's best, I think, if you have them reviewed by an attorney, but I'll tell you that my office won't do that,
Okay.
right? We want you to have the forms that we have. We also want you to make sure that you've got all the forms that you need. So if you come in, it's going to take us as much time reviewing everything that you did as it would for us to put something together for you. And we think that the way that we do it, the forms that we have, let me just talk about that for a little bit. We have a form bank that we are part of a group called Wealth Docs or Wealth Council. And there's thousands of attorneys throughout the United States, and we all pay something over $1,000 a month in order to have access to these forms and these documents, as well as the community. So we have the Wealth Council community, and everybody within that community is serious about estate planning because we pay our dues, right? So you're not going to find people in this group who are just like dabbling. They're doing divorces, they're doing whatever. They're serious about estate planning. And we all contribute. If somebody sees that, oh, this document needs to be changed because the law needs to be changed, they've got staff that are always changing those documents and making sure they're up to date. We have confidence in the documents, and we can recognize from across the room, oh, that's a document that some other attorney made, but they're a Wealth Council member because of the way it's formatted, and I can find stuff in there, and I know that it's a quality product. If you're downloading stuff from here or there, it would take me a long time to figure out where certain things were in the document, etc. So if you're going to do it yourself and you can find an attorney who will review it for you, that's much better. But if you're a smart person, I'm sure you are, read the instructions very well. Do some research online. Ask YouTube. There's a lot of I've done a lot of things about healthcare powers, financial powers of attorney. I'm always doing more videos. This is a video that'll be uploaded to our YouTube, etc. And you can learn a lot. I mean, there's information out there. You just got to be careful because some of it's not good.
So in that same vein, with the documents that you were talking about, the form bank, we can download the forms that are available, yes?
Not from the form bank that I use, but you can download Yeah, you have to be an attorney to get access to these forms.
Okay.
And then you have to subscribe, right? It's $1,000 a month. And who wants to pay that for their, just to do it for themselves? So there's forms out there. There's thousands of them on the internet. The quality of some of them is really poor. The quality of some of them is pretty good as long as you use them properly. But, even if, let's say, you're going to use something like trustandwills.com, you're still going to end up paying $1,500 or $2,000 for a complete package if you're doing a revocable trust package. It's much less than what we would charge to help you make sure that it's correct and all that. But it's still not a small price. But I'm sure you could find forms that are similar. It's just that you're taking a risk. Yes, sir.
Well, that was my question was, are we talking, like, if I'm not smart enough to know what I don't know, and I'm gonna have to hire somebody, and, is it $2,500, is it 10 grand?
Yeah, that's what I was
what's it
gonna
cost
ask.
Right.
To have you help me out? Can I get by with what, 5 grand, 2,500, 10,000, what?
So,
Ultimately, where are you?
now it all depends on what you need, and we can figure that out. I'll answer your question the best that I can.
Well, we can talk about it, I'll make an appointment, we can come in.
Sure, and I'd love it everybody makes an appointment. It doesn't cost anything. We'll sit down, but in order to pay for the appointment, we need you to fill out all your information on this sheet, client questionnaire, so that we can have some idea about your family and your finances and what it is that you are concerned about or what you want to accomplish. When we sit down there, we have some general estate planning packages that we customize depending on where you need to go. The lower end packages are about $3,800. The higher end packages are going to include multiple trusts, including irrevocable and revocable trust. Sometimes husband has a trust, sometimes wife has a trust. We've had husband's trust, wife's trust, and joint trust, plus irrevocable trust. Those can be $20,000, okay? It's very rare that we do them that expensive. But that is also $20,000 is what we charge people to get them on Medicaid while saving hundreds of thousands of their stuff, right? And sometimes it takes 2 years to get it done because there's penalty periods and all kinds of, we're fighting with the county a lot. But it's not cheap. But it's about a third of the cost of the heat pump and furnace that I just put in my house.
Well, there's value, I think, in having a smart guy helping you out. I can appreciate that, and that's why I wonder if it's 37, like if your average client is 37, probably an average person.
Yeah, so average is probably in the $5,000 to $6,000 range.
Yeah, I'm not overly worried about having to pay the money. It's, if you're competitive in the marketplace, that's kind of the question too. Other people, does everybody charge about the same, or are you a premium?
Well, we don't talk about prices with our competitors. Not really allowed. There's price setting or whatever there is. But the market is the market.
All right, I get it.
You can shop around. We think that we compare very well. Quality, value, price.
And once we meet with you, you'll be able to tell us about how much it would cost.
We'll tell you exactly how much.
Okay.
We'll say this is a flat fee. We'll do it for this. So, do we have appointments?
We do.
All right. So we have appointments available if you want to talk to our estate planning specialist. Then if you want to move forward, then you'll be sitting in front of an attorney talking about your plan.
So not necessarily you,
Wouldn't necessarily be me.
but
It might be.
Okay.
We've got 3 attorneys. We all do the same stuff. That's all we do. Yes?
Are all of your offices in Brookfield?
I've got Brookfield, Madison, and Oregon, Wisconsin.
Okay.
How do we meet, if we wanna work with Major Beans? Is that a premium?
You have to go to the Oregon office though. That's the only one he's allowed into. So Major Beans is our dog. And he's a mutt. We've got a little information sheet on him. He has 18 different types of dog in him. Yeah.
Are there ongoing costs?
There's no ongoing cost, but there is a subscription-based program that if you want to sign up, it's a nice idea to make sure that things don't get out of line. Because like some of you know here, if you've done your estate plan 10 years ago, you're not sure whether it's going to cover you. So we like to bring people back in regularly to say, did you get a new bank account? Did you get a new house? Did you sell something? Did somebody get married? Do you have more grandchildren? Do you want to change things so that your plan keeps up with your life? Okay. Thanks, everybody. I really appreciate your attention. It's a beautiful day out. I'm sweating in here, though, a little bit.
Thank you.
Thanks.